Hello viewers, welcome to my channel. I'm Hasham Ali Khan. So already two videos I have prepared on business law. Hope my regular viewers have already watched those two videos. In the first video on business law, I have explained you the meaning of the term law. What are the branches of law? What are the sources of Indian mercantile law or business law? And I have explained you all these things in the first video about law. Second video I have prepared regarding contracts. What do you mean by contract? And what are the essential elements of a valid contract? Then I have explained you about different types of contracts. So these two videos are the basic one. Now in the last video I have explained you that according to section 10 of the Indian Contract Act 1872, all agreements or contracts if they are made by free consent of the parties competent to the contract for a lawful consideration with a lawful object and are not expressly declared to be void. This is the definition given under section 10. So this definition says the essential elements of valid contract. The number of essential elements are there for a valid contract. Already I have explained you in the last video. So if you have not watched the first two videos, I suggest you to go to the playlist of my channel, select the subject business law, watch the first and second video. You can be able to understand the meaning of law, the meaning of contract. Now the first element of a valid contract is offer and acceptance. So in this video I am going to explain you about what do you mean by offer and what are the essentials for a valid offer. What is acceptance and what are the essentials for a valid acceptance? So offer and acceptance I am going to explain you in this video. From examination point of view, again it's very important. Every now and then a theory question will be asked regarding the offer and what are the essentials of a valid offer, or what do you mean by acceptance and what are the essential elements of acceptance. Now I am starting with the term offer. See, meaning and definition of offer I am going to explain you. An offer is a proposal. First of all, an agreement. What do you mean by a contract? A contract is agreement plus enforceability by law. Last video I have explained. So when an agreement is includes the enforceability by law, it will become a contract. So first of all, there must be an agreement. An agreement requires offer by one party and acceptance by the other party. So what do you mean by offer? An offer is a proposal. An offer is a proposal made by one party to another. An offer is a proposal made by one party on another in order to enter into a legally binding contract. Why the proposal is given by one person to another? In order to create legal relationship between the two parties. Right? The person who is giving the proposal is called the offerer. The person who gives the offer or the person who gives the proposal is called offerer, and the person who accepts that proposal is called offeree. So two persons are there, offerer and offeree. Offerer is the person who gives the proposal. So here the person making the offer is called offerer, and the person on whom the offer is made, proposal is made, is called offeree. This is the general meaning. So meaning of offer is a person giving the proposal to another person in order to make a legally binding agreement. When one person gives a proposal to another person in order to make a legal relationship, then it is called an offer. That is the meaning, general meaning. Now, definition according to section 2A of the Indian Contract Act. Indian Contract Act 1872 have explained the meaning of offer in section 2A. It says a person is said to make the proposal when he signifies his assent thereto, when he signifies to another his willingness to do or abstain from doing. Remember, this definition we cannot change. We can write in our own words regarding the meaning of offer, but definition same to same you have to write in examination. The definition given by section 2A, it says a person is said to make a proposal when he signifies to another person when he signifies to another person his willingness to do or not to do something. To do or abstain. Abstain means not to do. To do or abstain from doing anything with a view to obtaining the assent of the other person for such act or abstinence. I'll elaborate this definition. What do you mean by proposal? A proposal, when a person he signifies, when a person signifies to another person his willingness to do or abstain from doing, anything in order with a view to obtain the assent of the other person for such act or abstinence. Mr. A is giving the proposal to Mr. B. Why he is giving the proposal? In order to get the acceptance from Mr. B for the act which is going to be done by A. For example, A wants to sell his car. He is offering to B. He is asking B, will you purchase my car for rupees 10 lakh? Why he is giving the proposal to B? In order to get the assent from B. In order to get the response from B. If B says, okay, I will purchase your car for rupees 10 lakh, then a contract comes into existence. Because proposal is made by A and that proposal is accepted by B. So, what do you mean by proposal? A proposal, when he signifies, a person is said to give his proposal when he signifies to another person his willingness to do or abstain from doing. To do or abstain from doing anything with a view to obtaining the assent of the other person. For such act or abstinence. So this is the definition given under section 2a. Now example I have given. A offers to sell his car to B for rupees 3 lakh. A is offering to B to sell his car to B for rupees 3 lakh. And B says B agrees to A rupees 3 lakh for the car. B says, okay, I will purchase your car for rupees 3 lakh. Then what will happen here? A is called the offerer or promiser and B is called the offeree or promisee. So here I have explained you the meaning, the definition of offer and the example, right? So here essentials. Secondly, you must know what are the essentials of a valid offer. Every offer will not be a valid offer. There are many offers which may not become a valid offer. So you must know what are the essential elements of a valid offer. When an offer can be said to be a correct offer, valid offer. So these are the conditions. What is the first one? It must be capable of creating legal relationship. When the offer is made, the intention of the offerer is to make a legal relationship with the other party. That means every offer made will not give to legal relations. Example, a social invitation. A invites B on his birthday party to B. A invited B to birthday party. A's birthday is there. He is celebrating. So A invited his friend B. Now B accepted that offer. That means it's a social offer. The intention is not to create legal relationship. It is a domestic, it's a social offer. Even if it is accepted, it will not give any legal relationship. The first condition is when an offer is made, the intention of the offerer is to create legal relationship. The famous case on this point is Balfour versus Balfour, where husband promises to pay a certain sum of money as household allowance to wife. Later on, wife and husband are separated. Husband fails to pay the household allowance to wife. Wife sued in a court of law. The court dismissed the case, Balfour versus Balfour case, because there was no intention to create legal relationship when he makes the offer. When husband makes the offer, his intention is not to create legal relationship. It's only a domestic invitation, offer. So the first condition is the offerer must have an intention to create legal relationship. Secondly, it must be certain, definite, and not vague. The terms and conditions of the offer should be completely certain. It should not be vague. It should not be uncertain. It should not be ambiguous. For example, Mr. A says, Mr. A offers, I will take your house on lease for 5 years by paying rupees 2 lakh every year, provided you should properly repair the house and decorate the drawing room in such a way as to the present style. That means decorate the drawing room as such it is according to the present style. It's too vague. It's too uncertain. That means the offer given by A is completely uncertain. It will not give rise to legal relationship. It will not become a valid contract. Third one, it must be communicated to the offeree. When the offer is made, it must be communicated to the offeree. Without knowing the offeree, the offer is not valid. The best example for this, it must be communicated to the offeree, is a case where a person has declared a reward for his missing dog. A is a person, he lost his dog. He sent his servant to trace the dog. And after sending his servant, he declared a reward that whoever brings my dog, I will pay you 10,000 rupees reward. Later on, the servant searched the dog and brought it to Mr. A and claims the reward. So he has searched without knowing about the reward, because the reward was declared after sending the servant. The servant doesn't have the information about the reward. He brought the dog. Now he cannot claim the reward because it was not communicated to the servant. So in order to become a valid offer, the offer should be communicated to the person. Then only it will be valid. Next one, it must be made with a view to obtaining the assent of the other party. When the offer is made, the intention is I want to get the response from the other party. It is not simply an intention of doing something. Intention of doing something. It should be made in order to get the response from the other party to enter into legal relationship. Offer may be specific or general. Two types of offers are there. Specific offer means the offer is made to a particular person. He alone can accept the offer. It is called specific offer. But sometimes the offer is made general. General means to the whole public. When the offer is made to the whole public, it is called a general offer. Anybody can accept the offer and enter into a legally binding contract. So, specific offer, lapse of an offer. An offer may be lapsed due to death of the offerer or death of the offeree before acceptance. Before acceptance, if the offerer dies, or before acceptance, if the offeree dies, automatically the offer will be lapsed. Similarly, if a time period is given, suppose the offerer has given the time period to the offeree to accept it, and the time period has elapsed, then the offer is lapsed. Offer will expire. Similarly, the offer will lapse if it is revoked before acceptance. Before acceptance, the offer is revoked back, taken back. In that case also there is a lapse of offer. Next, an invitation to offer is not an offer. It should be different. Invitation and offer are two different things. For example, a shopkeeper has displayed goods in his display along with the price. That is not an offer. The public has to give the offer, then only a contract will take place. For example, Mr. A goes to a shop. There in the shop in display some item, some article is kept with a price of $10. Now the $10 is not the offer. That is invitation to offer. The shopkeeper is inviting the public to give the offer. Right? So offer should be different from invitation to offer. Offer should not include the term non-compliance. The offer should not contain a term, the non-compliance of which may amount to acceptance. Non-compliance of which amounts to acceptance. Such terms should not be used in offer. Example, Mr. A says, will you purchase my horse for rupees 5,000? If you do not reply within 10 days, I assume that you have accepted it. If he writes like this, the offer is not a valid offer. It should not contain a sentence that non-compliance of which amounts to acceptance. No. This type of sentence will not make a valid offer. Next, a statement of price is not an offer. When a particular shop has given some pamphlet, in that pamphlet some prices are given. That means the list of prices given in the pamphlet or menu, that will not a offer. That is not an offer. That is only an invitation to offer. That is only an information given by the person. The person can make the offer afterwards. For example, a pamphlet says that the article X is the article which is available at 100 rupees. That is printed on the pamphlet. A person has brought the pamphlet to the shopkeeper and says, you have written this item at 100 rupees. I want to purchase it. The shopkeeper says, no, I have not offered. That is only my intention to offer. Now you give the offer for 100 rupees. It depends on me whether to accept it or not. Last one, two identical cross offers cannot make a contract. Two identical offers cannot make a contract. Example, Mr. A offers. Mr. A says to Mr. B, will you purchase my horse for rupees 5,000? Mr. B says, okay, I will purchase your horse for rupees 4,000. That means the original offer was modified. A has quoted that, A has offered that, will you purchase my horse for 5,000 rupees? B says, okay, I will purchase your horse at 4,000. It's a cross offer. So the second offer will not complete the first offer. So as soon as the second offer is made by B, the first offer is elapsed, finished. Without acceptance, the first offer is gone. So no acceptance at all. So cross offers will not make a contract. So these are the elements of a valid offer. Next comes meaning and definition of acceptance. Meaning and definition of acceptance. A contract emerges from the acceptance of an offer. A contract will come into existence only when the offer is accepted. Until and unless the offer is accepted, it will not become a contract. So acceptance is compulsory to make it an agreement. Acceptance is the act of assenting by the offering. What is acceptance? It is the act on the part of the offeree to give his assent on the contents of the offer. An offer when acceptance becomes a promise. When the offer is accepted, then it will become a promise or it will become an agreement. So now definition given by Indian Contract Act 1872 regarding the acceptance. What it says, according to section 2B of the Indian Contract Act 1872, a proposal is said to be accepted when the person to whom the proposal is made signifies his assent thereto. A proposal is said to be accepted when the person gives his assent to the proposal. A has given a proposal to B. B has given an assent to this proposal given by A. It is nothing but acceptance. Made signifies his assent thereto. Now cases of acceptance, two cases are there. That is cases of acceptance. First, in case of specific offer. In case of specific offer, only that person can only accept to whom the offer is made. For example, A says to B, will you purchase my car for suppose 10 lakh rupees? A offers to B. It's a specific offer. No other person can accept this offer except B. It's a specific offer. General offer. In case of general offer, anybody can accept it. For example, a person had declared a reward. Anybody who bring my missing dog, I will pay you 10,000 rupees reward. So it's a general offer. Anybody can trace, anybody can get the reward. It's a general offer. Now types of acceptance. Two types of acceptance are there. Expressed acceptance, implied acceptance. Express acceptance. Express acceptance means when the terms of the acceptance are given in words, either spoken or written. When the terms of acceptance are given in words, either spoken or written, it is called expressed acceptance. Example, Mr. A tells to Mr. B, will you purchase my car for rupees 10 lakh? Orally, by spoken words. B says, okay, I will purchase your car for rupees 10 lakh. There is words expressed. So it is called expressed acceptance. Whereas implied acceptance, the acceptance which will be judged from the circumstances of the case, not required to be expressly given by words. Even by the act of the parties, it means implied acceptance. Example, a public service bus. A public service bus is plying between two places. So the bus department, is offering the services to carry the passengers from one place to another place. So whoever boards the bus, it is understood that he has accepted it. He should not say that I have accepted your offer. It is not necessary. As soon as a person boards the bus or boards a railway, then it is understood that he has accepted it. This is called implied. It will be judged from the circumstances of the case. This is the acceptance. Now, what are the essentials of a valid acceptance? It must be absolute and unqualified. The acceptance should be completely unconditional, unqualified. It should not have any qualification. Example, if A says to B, will you purchase my car for rupees 10 lakh? B says, okay, I will purchase your car for rupees 10 lakh provided you make complete servicing, provided you change the color of the car. That means it's a condition. It will not make a complete exact acceptance. The acceptance is not valid. It will not give a complete valid contract. So, in order to make a valid contract, the acceptance should be unconditional, without any condition. It must be communicated to the offerer. The contract will be completed only when the acceptance is communicated to the offerer. Till the communication is not complete, the acceptance is not complete. That means the contract will not come into existence. The contract will come into existence when the acceptance is communicated to the offerer. Next one is, it must be according to the mode prescribed or usual or reasonable mode. When the offerer has expressed that your acceptance should be according to so and so mode, that means the offeree should send his acceptance according to the mode specified by the offerer. If it is not according to, it should be reasonable, it should be usual. Then only a valid contract comes into existence. It must be given within a reasonable time. If specific time period is fixed by the offerer, then the acceptance should be made within that stipulated time period. If it is not specified, within the reasonable time period, acceptance must be done. Then it cannot precede an offer. That means always acceptance should be after making the offer. At any time, the acceptance can never occur before or giving the offer. Always offer should come first, then comes acceptance. It must show an intention on the part of the acceptor to fulfill the terms of the promise. Whatever proposal has been given by the offerer, the offeree, the acceptor should follow the instructions, what are the terms and conditions given by the offerer. Next one, it must be given by the party or parties to whom the offer is made. When the offer is made to a particular specific person, he alone must accept it. When A says to B, will you purchase my car for 10 lakh rupees? Only B can give the acceptance. C cannot give. C cannot come, I will accept your offer for 10 lakh. Because here the offer is made to B, so B alone can accept it. Then it must be given before the offer lapses or before offer is withdrawn. The acceptance should be given. The acceptance should be given before the offer lapses or before offer is withdrawn or taken back or revoked. Last one, it cannot be implied from the silence or failure to answer. The acceptance cannot be taken on the silence of the offeree. If the offeree is silent, he has not responded, then it cannot be treated that the offer is accepted. Silence does not amount to acceptance. So these are the essentials which makes a valid acceptance. So in this video, I have explained you about the meaning of the term offer. Then what are the meaning and definition of offer? What are the essentials to make a valid offer? What is the meaning and definition of acceptance? And what are the essentials to make a valid acceptance? Right? So In the next video, I'll continue this offer and acceptance. I'll explain you about the revocation, communication and revocation of offer and acceptance, and I'll explain you regarding the problems, practical problems on offer and acceptance in the next video. So if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos. And lastly, don't forget to subscribe my channel if you have not yet subscribed. Inshallah, we'll continue the same topic of offer and acceptance in the next video.